This is Bloomberg Law with June Grasso from Bloomberg Radio.
ICE! Murders! ICE! Murders! ICE! Murders!
Tensions are high in Minneapolis after 37-year-old Renee Nickel-Good was shot and killed by an ICE agent during the Trump administration's latest and largest immigration crackdown. Videos taken by bystanders with different vantage points show an officer approaching an SUV stopped across the middle of the road, demanding the driver open the door and grabbing the handle. The Honda Pilot begins to move forward, and a different ICE officer standing near the front of the vehicle pulls his weapon and immediately fires at least 2 shots into the SUV at close range, jumping back as it moves toward him. But there are dueling interpretations of the incident. DHS Secretary Kristi Noem called it an act of domestic terrorism and concluded that the ICE agent was acting in self-defense.
This vehicle was used to hit this officer. It was used as a weapon, and the officer feels as though his life was in jeopardy. It was used to perpetuate a violent act that this officer took action to protect himself and to protect his fellow law enforcement officers.
But Minneapolis Mayor Jacob Frey says the video tells a different story.
I myself saw a video of the shots being fired as the car was driving away. What I can tell you is the narrative that this was just done in self-defense is a garbage narrative. That is not true. It has no truth.
Joining me is former Manhattan prosecutor and criminal defense attorney Paul Callan, who's of counsel at Edelman Edelman. Paul, let's start with the very basic question of, can this officer be prosecuted? Vice President J.D. Vance, who's an attorney, says the officer is protected by absolute immunity.
Well, there's no such thing as absolute immunity for federal law enforcement officers. They can be prosecuted when they have used excessive force that violate federal rules and regulations with respect to the use of deadly physical force. So he's dead wrong about that. Now, on the issue of federal immunity, that's a more complex question, but I will tell you that there have been numerous cases through the years of federal law enforcement authorities being prosecuted on a state level for the use of excessive force. The most famous one was the Ruby Ridge case, which happened a while back. But in that case, there was a federal sniper who was assigned to try to take down the bad guys in the Ruby Ridge case. And the claim was that he used excessive force and killed somebody. And he was prosecuted in a state court, and it was upheld by the federal Ninth Circuit Court of Appeals. Now, that case was ultimately dismissed in the end, but not on federal immunity grounds. So federal authorities, if they misuse their right to use excessive force, they can be prosecuted, just like any human being can be prosecuted.
Are there separate rules for police and federal officers when lethal force is used against someone in a moving vehicle?
Well, yes, in the sense that some states, New York's a good example. In 1972, New York enacted a rule that police officers were not to fire at moving vehicles for 2 reasons. Number one, bystanders could be hit by the gunfire. And number 2, if they succeeded in killing the driver, the car could crash into somebody else and kill them. So it's a very, very dangerous thing to do. So that's been banned in New York at least since 1972. Now, other states have different rules on this. The federal government, basically, according to the Department of Justice manual, has a rule that they can only use what is considered to be deadly force when there's an imminent threat that the person they're shooting at would use deadly force against federal law enforcement agents or others. And that's how the feds would look at this case and judge it if they were willing to step back and judge it objectively, which that's a whole other subject. There's no objectivity being brought to this investigation by federal authorities from what I've been able to see.
Kristi Noem, the Department of Homeland Security director, has already for the past 2 days said that the woman who was killed here was aiming at the officer, and the officer was acting in self-defense and according to his training. And then you have state authorities saying, no, that's not the case. In past situations, has the federal government come out so strongly in presenting the narrative and the defense of the officer before there's even an investigation?
No, they have not. And as a matter of fact, Kristi Noem's statements are really shockingly inappropriate. Normally, federal authorities will make no statement, and this case would be looked at by the U.S. Attorney's Office that has jurisdiction, and there might be a presentation to a federal grand jury if it was a close call or if it was clearly misconduct, unlawful activity by the law enforcement agent. But they usually make no comment, no public comment, because who's going to believe that an investigation has been fair and impartial if all of the investigators have declared their opinion on it before the investigation even begins? So this is really improper and highly unprofessional behavior by Kristi Noem. And by the way, a person who said that is, of all people, Holman, who is called the border czar, who makes a lot of television appearances defending everything that the Trump administration is doing. And Thomas Holman has said that it's completely inappropriate for law enforcement authorities to be making definitive statements about whether this was a shooting that could be justified or not.
Minnesota investigators say the federal government is blocking them from accessing the evidence in the investigation, and the FBI won't work with them on the probe. So where does that leave the investigation? In the hands of the federal government that's already made a conclusion?
Yes, I think it will leave at least the initial investigation with the federal government entirely. Now, I have to say, June, that in situations that I've seen as a state prosecutor, and I prosecuted murder cases on a state level, the feds will come in on cases that have federal implications and pull the case from state authorities and take the evidence to begin with. But in the end, when they complete their investigation, the state is then free to pursue the case. And there have been cases where the feds have decided not to proceed with charges, and state authorities have said, no, this was a case of unjustifiable force, and someone was killed who didn't deserve to die, and state authorities proceed. That happens all the time. But it's not unusual for the feds to, take all the evidence and say, we're the only ones who are going to look at it initially. So Minnesota will get their shot at this case if the feds don't decide to proceed against the ICE officer involved.
Here you have videos, and videos taken from various angles. One would think that if there is a video, it would be pretty clear what happened, but is it? People seem to have different interpretations.
Well, yes, and this video in particular is one where people are disagreeing, because if this 37-year-old mother of three was intending to kill an ICE officer by running him over, would she have turned the wheels of her car to go to the right and avoid hitting the officer? That's something I'd be looking at if I were on the grand jury evaluating this case. The other thing that's very troublesome about the video, from my standpoint, is even if the vehicle was initially going toward the ICE officer, it looked from the video like all he had to do was step 2 feet to the right, to his right, and he would have been out of danger. She had turned the wheels away from him as it was. So it doesn't look to me like there was any imminent threat to him at all when he fired that deadly shot through the windshield of the car.
At trial, if this goes to trial, the jury's going to be shown videos from different angles. It'll be slowed down and stopped, and there'll be different interpretations from each side about what happened.
Well, and I think in front of juries, there's always great sympathy for the law enforcement officials involved in these situations, because they're making a snap decision about whether it's appropriate to fire a shot at someone who is presumably committing a crime. So they're hesitant about convicting a law enforcement officer under these circumstances. But here, first of all, you're going to get if you get a Minnesota jury, a Minneapolis jury, they don't seem to be people who are going to be very sympathetic to these 2,000 federal officers who have invaded Minneapolis now. There doesn't seem to be a lot of sympathy for the federal government in Minnesota. Now, remember, that's going to be the jury in this case if it's brought in federal court or in state court.
Paul, the other thing I noticed while watching the video over and over again is that the ICE officers are very aggressive. As they're approaching the car, they're already cursing. Also, they're all masked up so that you can barely see their faces. So it doesn't present what I'd call the typical officer situation.
It's completely atypical, June. I mean, we're used to seeing police officers dressed in a normal police uniform, which displays their badge number, and they don't have their faces covered like they're some kind of a terrorist operating in the Middle East, which when you see these ICE raids, it's a scene that's been never seen before in the United States, with officers with their faces covered raiding homes and firing gunshots into vehicles. It's a very, very strange and terrifying thing, I think, for American citizens to see. So that's what this woman was confronted with when, they were trying to pull her out of her car. And I don't know what her side of the story will be presented as. Obviously, she's not here to testify about it, but whether she deliberately came and was deliberately trying to obstruct this investigation or not. We don't know all of the facts at this point in time. But in the end, it comes down to one thing. Did this officer have an imminent threat of death being presented because this van was going in his direction? And was that the only reasonable thing that he could do under the circumstances? Fire a shot through the window at this woman? Or could he have merely stepped out of the way and avoided being killed himself? So that's what a jury will look at eventually.
Let's suppose that she was trying to avoid arrest and trying to escape from arrest. Does it change the situation at all, or the analysis of what the ICE officer did in shooting?
Well, on a state and federal level, there is a doctrine called the fleeing felon doctrine, which is if a felon who has committed a violent crime or is trying to commit a violent crime of some sort is fleeing the scene, generally deadly physical force can be used in that person's apprehension. But that doctrine has been narrowed down by the courts through the years, in recent years, and it's gotten to the point where in most states, you're not allowed to use that level of force just because a felon is fleeing the scene. You have to show that that felon actively presents a threat, an imminent threat of death or serious injury to other people. And that applied to this fact pattern, you would have to say, did she present an imminent threat of death or injury to members of the public or to this ICE officer as she was driving her car away from the scene? And from the video I've seen, I don't think it makes out that standard. But as we discussed earlier, there will be many angles of this video, maybe that we haven't seen yet. There'll be other information that we don't know about yet, which is why it's totally wrong for Kristi Noem and the vice president and everybody else to have reached a definitive opinion about guilt or innocence of this ICE officer. We've got to wait until all the evidence is in before we can make a determination about that.
In any event, will her family be able to sue in civil court for damages?
Well, they will be able to sue. There's no question about that. But I have to say that those cases are very, very difficult cases to win in federal court. The federal judges are very sympathetic to federal law enforcement authorities. And there are a number of rules in place in federal law granting tremendous protection to federal law enforcement authorities. As a matter of fact, it's if they violate the Constitution in the performance of their duties as law enforcement officers, that's not even enough to hold them liable. You have to prove that not only do they violate the Constitution, but that other officers wouldn't have known about the constitutional protection involved, and that only then maybe you would have a case for liability and money damages in federal court. Most of these cases are thrown out, and people recover no money in federal court. So they're very, very difficult cases to win.
It does sound like a really high bar. It's been great talking to you again, Paul. Thanks so much for joining me. That's former Manhattan prosecutor and criminal defense attorney Paul Callan. Vice President J.D. Vance called the Minneapolis woman who was shot to death by an ICE agent a deranged member of a large left-wing protest network without any evidence. And Vance declared with certainty that the mother of three tried to ram the officer with her SUV and that the officer acted in self-defense by opening fire on her.
What you see is what you get in this case. You have a woman who is trying to obstruct a legitimate law enforcement operation. Nobody debates that. You have a woman who aimed her car at a law enforcement officer and pressed on the accelerator. Nobody debates that. I can believe that her death is a tragedy while also recognizing that it's a tragedy of her own making.
But eyewitness accounts, video of the incident captured by protesters and city officials dispute those claims by Vance. And Minnesota Governor Tim Walz says he's skeptical that the federal investigation into the shooting will be fair, since the FBI has barred the state's independent investigative body from seeing the evidence or participating in the investigation.
From the president to the vice president to Kristi Noem have stood and told you things that are verifiably false, verifiably inaccurate. They have determined the character of a 37-year-old mom that they didn't even don't know.
And John Sandweg, the former acting ICE director under President Obama, says the videos raise troubling questions about the officer's actions.
I think it's been irresponsible, the department's position on this. I don't know why the secretary and department leadership rushed out with conclusions that this was a justifiable shooting. I think that especially when you look at these videos, and I think if the regular public looks at this, as we've seen, the regular public has serious concerns with it.
Joining me now to look at the broader implications of this shooting is immigration law expert Leon Fresco, a partner at Holland Knight. Leon, this shooting of the Minneapolis woman was not an isolated incident. ICE officers have fired on at least 9 other people in similar circumstances who were in their vehicles in the last year of these stepped-up immigration actions. And yet the administration and the Department of Homeland Security are doubling down today.
I want to be careful saying too much here because I think it's a lot of people are engaging in a lot of commentary without really getting to the actual facts of everything that led to this. And quite frankly, there are a lot of facts of a lot of different situations that all culminated in what happened in Minnesota, which is, if you're looking at this from one side of the perspective, you have a lot of foreign nationals in Minnesota being investigated for various fraud allegations against the taxpayers of both Minnesota and of the United States. And so the idea was that there needed to be a surge of resources to engage in that fraud. Then you could say a counter argument, well, but a lot of the people that were there doing this kind of law enforcement work for the Department of Homeland Security ended up arresting people who were not involved in any of those operations. And they're just saying they were picking up people who were just part of the normal immigration and customs enforcement menu of people that they would normally pick up who are undocumented and that weren't involved in these either daycare or other types of fraud actions that people are interested in the news and that are investigating. Then on the other side, you would say, meantime, there are efforts in big cities to stifle the activities of ICE, whether they be the implementation of sanctuary cities or individual protesters taking matters into their own hands. And on the other side, you could say there's agents from the federal government engaging in law enforcement operations that aren't the traditional detention, removal, and otherwise immigration prosecutions that have to do with removing someone from the United States. When they start engaging in actions that would normally be conducted by local police in terms of traffic or other things of this nature, then you have that issue. So all of these things come into play in the culmination of this one event where you have surges of thousands of agents in Minnesota with people who are opposed to that with all of the heightened rhetoric on all of the sides of this is something we've talked about in the past about perhaps a need for more solemnity in the manner in which immigration law enforcement is occurring. So there isn't this belief that the immigration law enforcement is meant to be overtly, purposefully hostile, but rather it's being done out of a solemn obligation to make sure that the immigration code has a meaning. I think it would be a very helpful change in tone for the immigration enforcement people to say, look, we have an 800-page book called the Immigration and Nationality Act, and 400 pages are all the laws about how you get here legally, and 400 pages are the laws about what happens if you break the law. And what's the point of having those first 400 pages that tell you that you have to do X, Y, Z things in order to get in the country if we don't enforce the second 400 pages? Because then there's no law. You just come in for whatever reason you want and do anything you want while you're here. So the point is there are good arguments to make, but they need to be made perhaps in a more solemn manner. And then at the same token, as people intend to obstruct or otherwise stifle immigration enforcement, they then have less of a justification for doing so, and their actions can be more targeted toward saying, look how irrational these people are that don't want us to enforce immigration law at all, as opposed to in a certain manner that might be viewed as particularly hostile. And that's the kinds of temperature that needs to be lowered. And then here, it's just going to come down to, at the end of the day, because there's obviously going to be a state attempt to prosecute this person. The federal government is going to say that this person has immunity, and the legal test is going to be whether the person acted in an objectively unreasonable or clearly unlawful manner under the federal use of force standards. And this is going to come down to a lot of things. Even the video angles, depending on what angle you look at, you might have a different take. Depending on whether you're talking about the first gunshot or subsequent gunshots, you might have a different take. We may find out that the communication that was held between the driver and the ICE agents added an extra context to this. So there are so many things that you have to look at this, that for anyone to rush to judgment on 1 day, 2 days, even a week after this without having all of the information in place, why was there so many ICE agents there? Why was there this stuff? Why was there the need to do any of this when none of this had to do with immigration detention, enforcement, and removal? But is there a need to do it because there was an operation that was actively happening that was being obstructed by this person? What did this person say to the ICE agents? All of this needs to be figured out before anybody can make a reasonable assessment as to who did what and were there good judgment calls or bad judgment calls. So I'm going to reserve my final opinion on this until all of those facts are obtained. But the only opinion I would give is I wish everyone else would do that as well.
Coming up next, we'll turn to the situation of Venezuelan undocumented migrants. You're listening to Bloomberg. The about 600,000 Venezuelans who fled instability at home are at risk of deportation by the Trump administration because the government has ended their temporary protected status and humanitarian parole. Homeland Security Secretary Kristi Noem said on Sunday that Venezuelans in the U.S. who were previously under TPS status can apply for asylum. I've been talking to immigration law expert Leon Fresco of Holland Knight. Quote, every individual that was under TPS has the opportunity to apply for refugee status, and that evaluation will go forward. Is this something new? Are they putting up asylum
again?
Well,
this happened already, basically, which was that every Venezuelan who lost their temporary protected status, who wants to remain here and not be undocumented, would have been given advice by their immigration attorney, look, if you actually do fear persecution in Venezuela, you should apply for asylum. So many of them did. And so many of the Venezuelans who had temporary protected status now currently have an asylum application pending that would need to be adjudicated in order to deport them. Now, this is going to lead to quite the conundrum legally, because I do think there will be people in the administration who will want to make the argument at some point, and the question will be when, hey, Venezuela is now a stable, wonderful place, So all of these asylum cases, whether it's 500,000, 700,000, a million, I'm unclear exactly how many are pending from Venezuela. Let's say there's a million of them pending from Venezuela. They will want to say, just dismiss them all en masse and don't have any asylum cases pending from Venezuela anymore, because we have a new government that's given us diplomatic assurances that every person that we deport to Venezuela will not be persecuted. So they'll try to get some sort of mass dismissal like that. And then you'll have, obviously, people litigating both individually and as a class that shouldn't be done. But then, at the same time, you have this, we've talked about this before, this famous Alien Enemies Act litigation, where the government has tried to say that certain people from Venezuela don't get any due process because the government is our enemy and they're in an act of war. And so they'll have to decide, do they want to keep that going? Because if they do, then the government is our enemy. They're not someone who is safe and you can go there and nothing bad is going to happen to you. So you're not going to be able to balance both of those balls at the same time, that Venezuela is a hostile enemy force that requires the invocation of the Alien Enemies Act, but also at the same time, nobody should be able to get asylum from this hostile governmental force. So there's a lot of decisions that the government's going to have to make, and they're going to have to make them within the context of what's actually going on in Venezuela. And I mean, I'm not there, but I read the articles that talk about that there are roving gangs and police that are going and asking people for their phones and seeing if they supported the U.S. And if they do, they're getting in trouble. And so all of those kind of things would seem like things you would want to be able to say in an asylum case, not a reason to dismiss an asylum case. So we're going to have to see how these events play out and what the administration wants to do with regard to these individuals in Venezuela.
I thought that the administration paused asylum decisions in November.
This is another issue completely that is a very excellent point, which is that if you're from Venezuela now or from 39 other countries, not only is there the issue of whether you can or can't get asylum or anything else, but literally all immigration decisions, period, whether you're applying for asylum, whether you're applying for the Trump Gold Card, whether you're applying for the EB-5 program, whether you married a U.S. citizen, all of those cases are currently paused right now. And I'm sure there will be litigation coming up soon saying that that violates certain statutes related to non-discrimination by country with regard to the allocation of green cards and also due process claims. I'm sure all of those litigations are being ready to be filed, both again individually and on a class basis in certain locations. But until those litigations get filed, at the moment, all of those cases are on pause. So all you can do is file these things. And unless people actually want to make decisions on these cases, then everything's just paused and we're in a state of flux. And so that is a very fair point that you bring up.
So now let's turn to this presidential proclamation. So the White House revealed it's more than doubling travel restrictions.
So if you recall, there was an initial list of banned countries, and that had to do with, again, there was the first Trump administration's list of banned countries. That list was taken away by the Biden administration. The Trump administration gets elected again. It has its first list of banned countries. It's 19 countries. And people thought that would be the end of it. There was some number of countries that were fully banned and others that were partially banned, were only non-work visas, meaning student visas or exchange visas or visitor visas. That's what's called a partial ban. There were countries that were partially banned. Then after this shooting that happened in D.C., where an Afghan person who came to the United States, you would call them a refugee, I suppose, who came to the United States and then murdered a National Guardsman. After that event, then there was a discussion about let's revisit this list. Let's see if there's more countries we should add. And so now, as a result of that revisiting, there's 39 countries on this list of full ban or partial ban. And some of the, most of the countries are in Africa and the Middle East. There is some Caribbean countries, Haiti, Venezuela, Cuba, But so there's two bans in place. One, there's a ban on people coming into the United States. But second, then USCIS, as we just discussed, has a separate ban that says if you're here and you're seeking to either change your status or get a green card or do an extension of your stay, whatever you're trying to do, we're just going to take your application and hold it in abeyance until some other announcement comes out later about whether we can vet you or how we can vet you or something else. And I do think, like I said, that's going to be subject to litigation because this sort of indefinite abeyance of applications, especially when you're collecting fees under the premise that those fees are being paid by people so that they would get an adjudication of their application, it's going to be challenging for the government to just permanently stick these cases in a drawer and not do anything with them. So they're going to have to express some plan of what it is they're going to do, how long that's going to take before they start re-adjudicating these cases. But they're going to have to do it at some point. And I think one of the interesting things to watch out for, not that this is the most important thing, but it is sort of symbolic of a lot of what goes on, is you have this administration saying this is going to be the best World Cup ever. We're going to have the most attendance. We're going to make the most money. The world is going to think this is the greatest thing ever. And I think there's about 5 or 6 countries who are participating in the World Cup where their fans are banned from coming into the United States. And I'm not just talking about a place like Iran, but I'm talking about Ivory Coast and other places like that, where it's, we don't usually have dangerous terrorists coming from the Ivory Coast. And so they're going to have to be a decision about, hey, will fans from these countries be allowed to come in to the United States, or will there really be no fans from any of these countries allowed to come into the United States to watch the World Cup? So it's mostly all the African countries that qualified will not be able to have their folks come in and watch the World Cup. So we're going to have to wait and see on that, but I do think that'll be another interesting thing to monitor.
So we talked before about the H-1B visa. Where does that process stand?
So there's 2 different developments in the H-1B visa world. One was, there was a proclamation under the same travel ban authority that said that if you were outside the United States coming up for the new visa lottery that's going to come up in 2026, you want a visa to enter the United States. So you're not here currently, you're outside and you want one. You're going to have to pay $100,000 in order to get that visa. There was a lawsuit. Many people thought that was going to be successful, but it turns out that lawsuit has not been successful. And the district court said, and this was a judge who's known as, liberal on many issues. She said that the travel ban authority is appropriately invoked here and that $100,000 fee can move forward. So now that's up in appeal in the DC circuit. We'll see what they want to do. But that was a very tough blow for a lot of these. It was the Chamber of Commerce who sued, who thought they were going to win pretty easily here. And I had told people from the beginning, I thought this would be a lot more challenging for the people suing than they realized. I always thought this would be a 50-50 case, and they lost in the district court. So when the new visa lottery happens in March, and those visas start getting allocated, if nothing changes, then if you're here in America, you don't have to pay that fee. But if you're someone working in India or Brazil or wherever, and they want to bring you in on an H-1B visa, that's going to cost $100,000. So that's the first one. The second one is a regulation that's going to be challenged, but hasn't been challenged yet, that just got finalized, that said that when we do the lottery for the 85,000 H-1B visa slots that exist, and that lottery happens in March, we're no longer going to do a blind lottery where each human being gets one lottery ball. We're going to change it, and we're going to say that if the company that's petitioning for you intends to pay you at the top 25% level of all people who get paid in the United States to do that job, then you will get 4 balls in the lottery. If you're in the 25th to 50th percentile, you'll get 3 balls in that lottery. If you're in the 50th to 75th percentile, you'll get 2 balls in that lottery. And if you're in the 75th to 100th percentile, meaning you're the lowest quadrant of pay, you'll only get 1 ball. So some people will have a 4-time greater chance of winning the lottery than other people, depending on how much they get paid, with the idea that the lottery slot should be allocated to the companies that pay the most, because the idea is that those are conceivably the people adding the highest economic value to the United States. This has been a bipartisan type of thing where those kinds of solutions have been proposed in the Congress. Many people thought that the Congress would have to be the one who would do this, that this can't be done by regulation. We're going to have to see what the courts say about it, because this wasn't done vis-a-vis the travel ban thing, like the $100,000 fee. This was just done based on the normal ability to regulate non-immigrant visas. So from that standpoint, we're going to have to see what the courts say. And this is going to have to get resolved before the lottery happens in March. So we'll see what they say.
The immigration laws don't seem to get any less complicated over time. Thanks so much, as always, Leon. That's Leon Fresco of Holland Knight. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.